So next we will move on to a very important topic in regard to the judicial appointment. It has been in news since 2 to 3 years, so you need to have an idea about what the issue is all about and what is the present status of this issue. So before that, we will begin with what is the existing procedure for making the judicial appointment. Now we have the Article 124 of the Constitution that deals with the appointment of the judges to the Supreme Court, and it states that it should be done by the President in consultation or with the consultation of the judges of the High Court as well as Supreme Court as the President deems necessary. So it is being done by the President. Similarly, you have Article 217 that deals with the appointment of the judges to the High Court. Even though we have these two articles in specific, we have another mechanism that got evolved over the years through various cases, like that of the first judge case, second judge case as well as third judge case, and that has resulted in what you call as a collegium system of appointment that is followed presently in making the judicial appointment. Now what is this collegium system of appointment? It is simple. In regard to the Supreme Court, the names of those who are eligible to become the judge of the Supreme Court will be recommended by a collegium that consists of the 4 senior-most judges of the Supreme Court and also the Chief Justice of India. So this will be the collegium, and it will recommend the names of those who are eligible to become the judge to the government. So that is the first case in regard to the Supreme Court. Secondly, in regard to the High Court, what happens is that you have a 3-judge collegium system at the High Court level that includes even the Chief Justice of the High Court, and that particular collegium makes a recommendation to the Chief Justice of India, and the Chief Justice of India, in consultation with the 2 senior judges of the Supreme Court, will recommend the name to the government. So this is what is being followed. That is the Supreme Court consisting of the 4 judges. As in Supreme Court, you have the collegium consisting of the 4 senior-most judges and also the Chief Justice of India. And also in High Court, we have a 3-member collegium that refers it to the Chief Justice of India, who in consultation with the 2 senior-most judges of the Supreme Court makes a recommendation to the government. So this is in regard to the collegial system of appointment. But there has been criticism in regard to this collegial system of appointment. Now what exactly is this particular criticism? In regard to the criticism, the first and the foremost is that it lacks transparency. Now in regard to the what particular criteria has been used to make the appointment, it is not placed in the public domain. So we don't know what exactly is the criterion that has been adopted to make this judicial appointment. That's the first thing. So it lacks transparency. Secondly, the recent cases of the former Calcutta High Court judge, so that and the related indisciplined behavior, that and all has resulted in the questioning of this particular collegium system of appointment. So that is the second case, recent case of former judge as well as other judges against whom the allegations, several kind of allegations have been made. So that is another case. And then you have even the lawyers unaware about this process, whether they are being considered as a possible candidate for the position of the judge, and what process is being used, and why their counterpart got appointed. So such kind of transparency is not there. So these have all resulted in the criticism of this particular judicial appointment method. So what was proposed was formation of what you call it as a National Judicial Appointment Commission. Now it was as per the recommendation by the Venkatacharya Commission, and this commission recommended the replacement of this particular collegial system with what do you call it as a National Judicial Appointment Commission, which had its members from the executive as well as the judiciary. And as per this particular recommendation, the government brought about the 99th Constitutional Amendment Act, which aimed at replacing the collegium system with the NJAC. But what happened is that it was struck down at the Supreme Court in 2015. So what happened is that the Supreme Court struck down by stating these 3 reasons mainly. Now what are the reasons? The first thing is that the executive getting involved in the appointment means the executive breaching its particular jurisdiction and entering into the jurisdiction of the judiciary. So that was seen as impinging or encroaching or breaching the separation of power doctrine. So that is the first thing. Second thing is that veto power to any two members will result in any two members of the executive vetoing the powers that is taken by the judiciary. So that will also affect the independence of the judiciary, which itself is a basic structure of our constitution. So these were the main reasons that was stated by the Supreme Court while striking down the NJAC, that is 99th Constitutional Amendment Act. That is, it impinges on the separation of the powers, and then you have the veto provision to any two members, and then affecting the independence of the judiciary. So these were the main conditions. But along with the striking down of the 99th Constitutional Amendment Act, the Supreme Court also put forward what you call it as a Memorandum of Procedure, and it stated that the sender needs to draft a Memorandum of Procedure in consultation with the judiciary to streamline the judicial appointment. So that is what resulted in what you call it as a Memorandum of Procedure. That is mainly, it aims at streamlining the judicial appointment. So while making this particular recommendation for drafting an MOP, that is Memorandum of Procedure, the judiciary mainly looked into 4 points. The first thing is how transparency can be brought in the appointment. Secondly, whether there is a need to establish a secretariat to do the screening activities, and if it is to be established, what kind of powers and functions should be allotted to it. Thirdly, whether there is a mechanism that is that should be there to look into the complaints, and also the eligibility criteria. What has to be the eligibility criteria while making the appointments. So these were the main points that was touched by the Supreme Court while making the recommendation for drafting the Memorandum of Procedure. So what happened is that following the years, there was a discussion that was happening between the government as well as judiciary regarding the various provisions of the Memorandum of Procedure, and certain provisions were being accepted, mutually accepted by the judiciary as well as the government. Now what all are those points that were, or that recommendations that were accepted? The first thing is in regard to lifting the proposed cap. That was earlier the government had proposed a cap of 3 to those advocates as well as jurists who will be appointed to the position of judge. That is, only 3 among the jurists or the advocates were allowed to be appointed as a judge. So that cap of 3 was there. But what happened is that following the discussions, that particular cap for the lawyers as well as jurists was being relaxed, and now there is no cap for the appointment of the jurist or the lawyers. So that is one thing. Second is that after the discussions, it has been now finalized that seniority will be the main criteria for the appointment of the judges. Along with it, the merit as well as the integrity of the judges or the candidates will be considered. So that is the second thing. Third thing is in regard that was recently being accepted, that is regarding the age limit for the appointment of the advocates, that the age limit has been proposed to be minimum of 45 age as well as maximum of 55 age. So this has been the age limit that has been set for the appointment of the advocates. So these are the main provisions that has been accepted by the judiciary as well as the government. But even though there has been a mutual acceptance, the MOP that was suggested by the Supreme Court in 2015 ruling has not yet been formalized. It has been due to the various disputes in certain clauses. So what are these clauses? The first thing is in regard to the national security. Now the clause goes like, the government will have the powers to reject any candidate that is recommended by the collegium on the grounds of public interest or national security. So the government will have the power to reject. So that was that the judiciary found this particular clause stating as they said that such a clause of rejection would affect the independence of the judiciary, and that can also lead to the politicization of the judiciary or judicial appointment. So what it said is that in cases of rejection, the government should put on record the reasons for the rejection. That is, the judiciary stand was that the government will have to put on record the reasons for the rejecting any name that is recommended by it. But the sender said that it would convey it only orally, because if it is given in a written record and even then the judiciary goes forward with the particular appointment, that could affect the credibility of the judiciary as an institution, and also it can affect the record of the particular person who has been rejected or whose reason has been stated. So that was said by the judiciary, that is a problem between the judiciary as well as government in regard to the clause on national security. The second clause is in regard to the setting up of the secretariat. Now the secretariat was being proposed in order to ensure the screening of the appointments to the higher judiciary. So that was being proposed. So the government stand was that it supports the establishment of such kind of secretariat that will ensure that the proper screening happens, and but the judiciary is saying that the present procedure in which the personal staff of the judges who are a part of the collegium does the screening is good enough, is more than enough. That is what was stated by the judiciary. So this is the issue all about setting up the secretariat. That is, the government supports this particular establishment, but the judiciary says that the present mechanism where the personal staffs of the judges who are involved in the collegium or who are the members of the collegium doing the screening is more than enough. So that is in regard to the setting up of the secretariat. Now third is in regard to setting up of a committee to deal with the complaints regarding the judges, and in this case what has been proposed is that 3 judges who will be not the members of the collegium will be appointed to look into the cases of the complaint in regard to the Supreme Court as well as the High Court. But this has been not finalized between the judiciary as well as the government. So these are the main issues, that is in regard to the clause on national security, in regard to the setting up of the secretariat, as well as for a committee to deal with the complaints of the judges. So these are the main issues that have affected the formalizing of the memorandum of procedure. So this has been cited as a main problem that has resulted in the present state of the judiciary. But it is not so, because it is not just about the judicial appointment, it is a holistic reform that is required if the judiciary has to be made more efficient in its functioning. So what are the changes that can be suggested? The first thing, of course, it is regarding the finalizing of the memorandum of procedure, and that has to be done as fast as possible, and for that the judiciary as well as the executive have to come together and they need to discuss on the reservations and finally end up with a transparent as well as a professional mechanism of appointment. So that is the first thing. Second thing is in regard to the establishment of National Court of Appeal that could deal with that could serve as a final appeal court in regard to the criminal civil cases, and that can relieve the Supreme Court of such kind of appeals, and the Supreme Court will be able to concentrate more on the issues in regard to the public interest as well as those affecting the public interest as well as those of constitutional importance. So that can be looked into by the apex court in an efficient manner, and strengthening of the lower judiciary, and that when done can lead to the reduction of the appeals that is presently happening to the higher judiciary, be it in the High Court or the Supreme Court. And then we need to decide on a recruitment examination, and the lately suggested central selection mechanism is one such way out. And then such kind of mechanism along with the proper pay as well as a career advancement can lead to the strengthening of the lower judiciary. And then you have the introduction of technology in the court proceedings, like that of the the video conferencing, and that can result in reducing the cases of adjournment, and that can help in the easy winding up of the cases. And then you have ensuring the women representation. As I have already told, it is just the women is constituting only about 10% of the total judges of the Supreme Court as well as High Court. Now that has to be increased, and it can improve the quality of the judiciary in a much better manner. And then you have the role of government. It involves in giving more funds as well as looking into the sunset legislation. So this is just in a nutshell what all the changes are required. So that is all about the judiciary. So the main concept is about the judicial appointment,